business sales and purchases. This is an area that I've been working in now for 10 years, and it really is, today could be very turgid, and I'm trying my hardest not to. I was up at 5:30 this morning, which is pretty sad because I was excited about doing this. I used to be invited to lots of stag do's and parties, but now this is my level of excitement in life. But business sales and purchases happen all the time, and what we're going to be focusing on today is purely asset-based business sales and purchases. There's a few agents here that I know that deal with those kind of businesses, so we're not going to be dealing with corporate transactions, sale of shares, because that is another subject altogether. It's a very, very complicated area. There is some overlap between asset-based business sales and purchases, businesses are going concern, as well as share sales, but the share sales really, they do involve a lot more due diligence and a much larger contract known as an SPA, and we don't want to get into that today. So today we're going to be talking I'm sorry about the slides as well, the television. This is budget cuts at Sussex, so they should have a much bigger TV really, but I've tried my best to do the fonting and everything. So just what I'm going to do is I'm going to give you an overview of the process, how it works. We're going to talk about due diligence and inquiries, what, when and when. Inquiries, of course, specifically designed to piss off every agent that you can have on a deal, just to make sure we're at the inquiry stage and that really gets them going. We then talk about the contracts and ancillary documents very briefly, what's involved, what we actually have between the parties. We then talk, and I'm going to specifically focus on this point, which is the warranties, indemnities and guarantees, the protection mechanism, why they're important, what they do between the parties, and how obviously both buyer and seller try to protect themselves post-completion. 2P and staff inquiries, well, I'll briefly touch on 2P, that's quite an important aspect. Restrictive covenants and post-completion protections in terms of how you can stop your seller from basically opening up opposite you once you sold your business, and it does happen, believe me. Hairdressers are the best ones for that. They really are, like the level of bitchiness in the hairdressing business is unbelievable. Then Hamish is going to talk about the property aspects, transfer of a lease and considerations, freehold property issues and finance, completion process, and then I'm going to share some horror stories with you, some quite funny stories as well, things that happen. I know law doesn't seem funny, but there can be some funny moments, especially when you're working with Hamish. So this is how a business sale and purchase as a going concern happens. There are two aspects to a business purchase. One is the property aspect, and you have to separate the two. One is either you've got a freehold property or a leasehold property, and the other aspect is your business. So you need to separate the two. Although, let's say, for example, let's use a hairdresser as an example. You've got a hairdressing salon with 10 staff. The lease is a separate matter altogether to the business aspects. The business has staff, it has contracts, it has leasing agreements, it has suppliers, it has debts, it has everything that's relevant to the business. The property itself is separate. So you have to consider the two separately, and that's quite an important thing to do. So when the business gets put up for sale by the seller, you have an agent. Now the agents, and like I said, there's some of you in this room, there's very good agents in this room actually, so, marketing. And what a good agent does, he or she is the glue that keeps the deal together. So what they do is they collate the information and they put it together for the seller to be able to promote their business and sell it. That's what a good agent should do. Then buyers come to the agent, and the agent then obviously gives the information to the buyer. So we then, once the agreement between the seller and the buyer has been put together, we then get what's known as heads of terms or memorandum of sale. Now, at this stage, I've just got to say that this is a very preliminary stage. We get the client details, we're either acting for the seller or the buyer. We do our bit, which is client engagement, letter opening the file, money laundering, origin of funds, etc., all the fun bits. We then obviously look at the heads of terms, and this isn't a gripe, this is just at this stage, sometimes this particular aspect is missed from a buyer and a seller's point of view, and this is a non-disclosure agreement, and it can happen quite a lot. So for example, I've recently been instructed to sell a nursery business, and the agent was given a lot of information from the seller, accounts, information on staff, management structure, etc. Just normal information that you would get. This was disclosed, all of it, to a potential buyer. Now the buyer actually had a nursery opposite this nursery. I mean, the mind boggles that they just gave all their information to someone that's got a rival business opposite them. But there was no non-disclosure agreement here. Now, the agent is under no obligation to either party because the information isn't relevant to the agent. So it's important here that when you actually look at this aspect, you touch on the non-disclosure agreement. There are other issues that you need to obviously think about here, such as taxation. Who's buying the business? Are you buying as a limited company? Do you want to get SEIS relief, EIS relief? How are you doing it, the transaction? So we look at all of that, but the heads of terms are issues. So that's the first step. We then obviously open the file and everything else that I said, and we move on to the next stage. We're acting for the seller. We draft a contract known as a business sale agreement, and then we send that to the buyer's solicitors. The buyer's solicitors will send us their inquiries, and their inquiries can be long, short, tailored, etc. Every business will have different inquiries. At that stage, obviously, we then look at considerations that are relevant to the client, such as staff, pensions, contracts, assets. I've listed all this, and you can have all these notes at a later date if you want. I don't want to just be reading what's on there. Once we've got the contract and the inquiries, we then move to amending the documentation and making sure everything's tailored to what our client wants, either the seller or the buyer. At that stage, we negotiate the warranties and the client requirements relevant to those warranties, and that's where I want to focus most of today on. At the fourth stage is we prepare our reports and client expectations. We sit down with the client, we give them the report on the lease, we give them a report on the title, we give them a report on the business, on the inquiries that we've raised and the contract, and we explain to them where there's any risk. At that stage, once they're happy and everything's signed, a lot of them just don't, obviously you sit there and you make the attendance note and you make sure that your arse is covered, that obviously at a later date they don't come back and go, oh, I didn't know. And that happens a lot, but good lawyers will obviously explain things as best as possible and pick the showstoppers out. We then have a final review, and once everyone's happy, the money's on its way, etc., we then exchange, complete, and deal with any post-completion matters. That, in a nutshell, is the process of how a business sale works. It sounds easy, but there is a lot involved in that. How do we estimate our fees, actually? I was thinking how I could explain this. It's difficult. Every business is different, and every transaction is different, and everything involves so many different things. The current market, I find, for legal services is everyone is shopping for fees. It really is a fee-driven market. I don't know what it's like in other areas, accountancy or surveying or valuations, but we give a very holistic service. We look at every aspect. We give the client the best possible service. We know what we're doing. We've been doing this a long time, and we actually really think about the type of business they're buying or selling. But we lose out for people that are shopping on fees. We made a conscious decision a couple of years ago that we would only focus on the best work because the clients are happy to pay for the best work and get the best service. So it is a bit difficult. You have to be competitive, but when you know how much is involved, it's very difficult. And I've just explained a very simple process there in 6 steps, but there is actually a lot involved in that. So moving on, inquiries. I'll just quickly explain that when we raise inquiries, now I've been doing this for a while now. I know I don't look it, but I have been doing this for over 10 years. And I've got a list of tailored inquiries for almost every business that I've bought and sold. I bought a dog grooming business 10 years ago. I still got the inquiries. Pup Idol. That's one of my favourite businesses. I still got the inquiries relevant to that. I've got inquiries to dental practices. I've done quite a lot of dental practices. I've got hairdressing businesses, dry cleaning businesses. So what you do is you tailor your inquiries to the business acting for the buyer. From a seller's point of view, as a solicitor acting for the seller, when you get inquiries that are like 2 pages long, you just know that this is going to be either an easy deal or the guy doesn't know what they're doing, or the person on the other side doesn't know what they're doing. So we look at obviously the type of business that we're buying or selling. We tailor the inquiries to them. Such inquiries, such as staff inquiries, you really do need to know about staff, pensions. Have they been properly set up? If they're with Nest, did they meet the deadline? Is everyone set up properly? Have they, who's the administrator? 2 pieces of consideration I'll come to later. Have the staff got contracts? These are all really relevant matters when it comes to a business. Our employment team deals with that. Adrian, who's not here today, but we pass that on to our employment team. Equipment and assets, what are we buying? Are they in good working order? If you're going to be buying a cheese slicer, can it slice cheese? It's as simple as that, really. And you'll be surprised how many people you have who are buying a business who don't even look at the assets working before they buy it. We get the warranties, and I'll explain how that works later. I'll give you an example. We bought a catering business recently, and there was a 30 grand walk-in fridge. We had the maintenance report from the last year, but the client didn't check whether it was working before completion. All they'd done was 2 checks of the business and walked round. Day after completion, calls us up and says, the fridge isn't working and we need to have it fixed, and it's about 6 grand. Luckily, we had the right warranties in there to protect the person, but they had to sue under the warranties to get the fridge fixed by the seller. So you make sure that what you're buying works. GDPR is a big thing now, data. A lot of businesses send their data out by MailChimp or Facebook or social media. If you're transferring that data to a third party, which is your buyer, do you have the right authorization? You can't just say, here's my MailChimp account anymore. Do they have policies for privacy? Do they have a policy for their staff and GDPR with people that are supplying them? These are all really relevant, even their accountants. If your payroll's set up by an accountant, you need to have a service agreement with the payroll department of the accountancy firm that GDPR, they're complying with certain aspects of GDPR. So contracts, leasing agreement, book debts, litigation, we look at all aspects of it, and also stock. What are we buying? Some businesses have a lot of stock. If you're buying a newsagent, they're going to have 30, 40 grand of stock. And I've put here, if the cheese slicer works, make sure the cheese is actually sellable. So, people do need to look at what they're buying. So this is what we do on the inquiry stage. And that can take quite a bit of time. The seller's got to collate it. Moving on, there's other types of inquiries here that, regulatory stuff such as PRS licenses, health and safety requirements, fire risk assessments. Hamish will touch on quite a lot of regulatory stuff with the property aspects that we deal with. But inquiries as a whole, this is very important. What we do is we make sure the contract refers specifically to the inquiries, and the warranties, which again I'll come on to in a minute and why they're so important, they reflect the accuracy of the replies to inquiries. So we would expect the seller to give a warranty to the buyer that the inquiries provided are true, accurate and fair, so that if they are not, we can come back at a later date and say, well, you either lied or you weren't aware, and you should have been aware using your reasonable endeavours. So that's what we do on the inquiry stage. The next stage is obviously we get the contract if we're acting for the buyer from the seller's solicitors, or we draft a contract. Now the contract itself is pretty much standard now. We have what's known as a PLC, practical law company, provide a precedence for all law firms. They get tailored obviously, but there's pretty much a standard document. Main provisions, you have parties, definition, you have a definition section, you have a buy and sell with title guarantee provision, you have apportionment of purchase price, and this is very important here. When you're selling a business, I just sold a hotel, we actually completed yesterday, and it was just under £1 million, but the apportionments went primarily to the property. Now, you need to speak to an accountant as to that, because it has massive tax implications for the seller and the buyer. If the buyer sells it on in the future and makes a profit, but then allocates most of it to goodwill, there's a different taxation there. And obviously the property aspects, if they make a gain on the property, there's a different taxation rate there. So it's important to make sure the apportionments are right. What we do is when we get, please check the apportionments with the accountant in bold, underline, then that's ticked off on our list of liability. Apportionment of outgoings is another provision. Who's going to pay for what up to completion. If you've paid for things after completion as the seller, you want to be able to reclaim that, if it's licenses or premises license or whatever kind of license. And likewise with the buyer, you want to be able to make sure that anything that should have been paid gets apportioned between the parties. You have a restrictive covenant, you have VAT issues, you have a provision on that. So a transfer of a going concern under VAT Act is not vatable, but only if the buyer and seller are both VAT registered on completion, or the buyer on a reasonable period after completion. So that's important as well. Risk, how that gets transferred. And obviously the contract as a whole, as I said, it's quite standard, but these provisions, a good lawyer will know what needs to go in there, and they can obviously, I'm pretty confident now that I could probably blindfolded draft the contracts based on what I know needs to be in there. So yeah, we look at all of that, and then we get on to the most important aspect and what I really want to speak about today, which is warranties. So when you buy a business from a buyer's perspective, what you want is the seller to represent to you that on completion, that bad is it, Hamish? That on completion a certain position exists on completion that you can rely on. So for example, I'll give you an example of a warranty. A warranty, let's say the hairdresser business again. You have a warranty that the business is not subject to any litigation or any pending litigation or tribunal, and the seller will warrant that to you. So if after completion it becomes apparent that actually one of the staff members was having an issue with another staff member and there would have been a claim, a reasonable person would consider a claim to have come up, you can, as the buyer, go back to the seller after the event and say, look, you should have told us about this. You need to obviously pay up, and we're going to put you on notice that there could be a claim that you'll have to be responsible for, because this was for the period of your ownership. So warranties are hugely important in these contracts when you're buying and selling a business, and they're probably the biggest area of negotiation, I would say, in the contract. So we ask for all sorts of warranties. We have standardised warranties that we put into the contract, but then again, as I said, with the inquiries, we've got tailored warranties as well, things that are relevant to every business. So for example, nursery businesses, you would 100% want warranties in respect to Ofsted regulation, in respect of staff and planning. I know you'll be touching on planning later, but nurseries, there are limitations on how many children, for example, can be outside at any one time and under supervision. Now, people miss that when they're buying and selling nurseries, but that's one of the really big aspects. So you need to make sure that the warranties comply with the reality on the ground. So that's from a buyer's point of view. From a seller's point of view, what you want to do is limit the scope of the warranties massively. You don't want to be eternally obliged to the buyer going after completion. You've sold the business, you've given them all the information, they need to make a go of it from there. But what you do need to do is balance that and give them some protection, something that they can hold on to, that they're happy to sign the contract. So how do we limit the scope of warranties when we're acting for a seller? There are many ways, but these are the four main ways here. The first one is de minimis, and in Latin, I don't know what that means. I was going to pretend that I knew, but I don't. But I know effectively what it means is a limit, a minimum limit on what you can claim. So let's say you're selling a business for £100,000 as a going concern. You usually say between 1% and 3% has to be the figure for a claim to be able to be brought to you. So £1,000 to £3,000. We usually start off at £1,500. So the minimum amount a claim must be is £1,500. The reason for that is what you don't want is every single claim being brought to your door. So you just cut it off at that limit. The second way that we limit the liability acting for a seller is what's known as aggregate liability. So what you do is you say, right, notwithstanding that you've got £1,500 is the minimum you can bring, the aggregate liability of any number of claims has to be a minimum of, let's say, in this instance, £5,000. So they have to realistically have 4 claims of £1,500 or 2 of £3,000 or 1 of £5,001 to be able to claim. And that's important because actually that knocks out a lot of claims, and good solicitors acting for buyers will reject that. But when they don't, you know, and I have to go back to the hotel example yesterday. We sold a hotel just under £1 million, and the buyer solicitor, I sent them a contract with no warranties, none of this, they just accepted it. So the buyer's got absolutely no protection post-completion, and they've just paid all this money for a business. So it is very important that you get someone that knows what they're doing. Third way, time limitation. Now, time limitation is usually agreed between the parties as what's left of the tax year plus 1 tax cycle. So if you think about it, if a 12-month tax cycle and you buy the business halfway through a tax cycle, you've got 6 months plus 12, and then you add another 6 once the accounts get done. So you would argue for 2 years. In share purchase agreements, it's usually agreed at 2 or 3 years. In business sale purchases, a going concern, 12 months to 24 months. If you give any more than that from a seller's point of view, you're keeping yourself open for a claim indefinitely. Added to that, you also have a provision that says that they have to notify you within, I mean, this is up to negotiation, 28 days or 56 days of becoming aware of a claim. So these are very important provisions from a seller's point of view. And the fourth way, and this isn't exhaustive, but these are the 4 main ways, we say that the buyer has to sue any third party that's liable before they sue the seller, or use insurance. Very important ways of limiting that. So obviously I've given you some examples of warranties. Another warranty with respect to equipment would be that they're all in good working order and properly maintained. And if obviously they're not, we had that warranty when it came to the walk-in fridge scenario. So our client could sue under the warranties, and it was within limits as well, because it was 2 days or a day after completion. So that's why warranties are so important in the contract, and the process takes a bit longer is because of negotiation over this area. So we enforce the warranties by issuing a claim against the seller and putting them on notice. Having the warranties, just to make this clear, doesn't mean you're guaranteed to win. If the seller sticks their foot in or has disappeared, I mean, that's another thing. Obviously, you've got to be able to sue the person that's got money. You're not guaranteed to win. You have to chase them, and that's a reality of this process. So that's why inquiries are so important. Making sure you know as much about the business is so important, and then having this protection. And that's why this process obviously takes a bit of time. So just to give you a quick example before Hamish comes on for his area, we just sold a lettings business. And this is just to give you a flavour of what involved with us. Sold a lettings business that had about 150 properties under management as the letting agent. Bless the person that was in charge of tenant deposit schemes, they didn't have a clue. We asked the seller to confirm, is everything okay? They've asked this inquiry, and the inquiry specifically was, and the warranty, that all regulatory matters and tenant deposit schemes had been properly maintained, kept, etc. They hadn't. It was about 20% of the properties of 150, if you think about that didn't have the tenant deposit scheme properly maintained, or in some cases even put in place. So the buyer came to us and said, look, we're putting you on notice that there's a breach of warranty. It's an interesting one actually, because there isn't a claim until the landlord's claim against the letting agent that they bought. And there's only a claim if the landlord's sued by the tenant. And they can't actually instigate the claim by telling the tenant to sue them, because they would vitiate the provisions of the warranties. So it's a long drawn matter, but you don't want to be in this position. So from a seller's point of view, make sure what you're saying is accurate, and you've actually made proper inquiries. And some of the agents in the room here will know how many times it happens where the seller just goes, I don't know, or yeah, just put that, that's fine. And you need to really focus on that. So this is what we do basically, and this is the process. This is the most important aspect. So 2P pensions and staff I've touched on. 2P is a minefield. It's called a Transfer of Undertaking Protection of Employee Regulations. It's designed, and properly so, in protecting employees on the transfer of a going concern business to make sure that their terms and conditions, their contracts, are not effectively vitiated, changed, or that they're sacked on because of the transfer of the business. So it is very important. I'll briefly touch on, there are some ways that you can obviously get rid of employees on the purchase of a going concern. They're called ETO reasons, economic, technical and organisation. Very complicated, not for this, that's a whole seminar and a webinar on its own. But essentially what happens is the seller needs to give as much information about the staff as possible under Regulation 13 and give that to the buyer. Age, date of birth, contract, pay, when they started, etc. All of this information, so the buyer can then know what the staff are. And this is a really important aspect actually, to make sure that you get right. And we, actually funny enough, we were talking about this on the car over here. Hamish was on the other side of a deal before he joined So Legal, and I was acting for the seller. And there were two members of staff that the seller just hadn't mentioned at all until the buyer solicitor, who was Hamish, the employment team, said, is this all the staff? And the accountant sent a big list of staff. Two members of staff were on long-term statutory sick. We're talking 5 years plus here. And the sellers had just paid their statutory sick pay very nicely. They'd never done anything about it. And of course, some busybody on Hamish's side, I'm joking. One of the employment team on Hamish's side, but at his old firm, said, have they been paid their holiday pay? We want them to enter into compromise agreements and leave. The two staff members went to Citizen Advice Bureau, and they were told, quite rightly, that actually they hadn't been paid holiday pay, they had to be paid. We were getting, I think, around £100,000 for the business, not even that. Our client ended up paying 25% of the business to these two for compromise agreements. So it's just so important to get all your information right and disclose it properly and get it out there, and actually make sure that all of your employee documentation. I mean, we employed a solicitor recently, and they came from another firm. Yeah, let me have a look at your contract. Let's see what your restrictive covenant is. I don't have one. This is a law firm that doesn't have a contract of employment with its staff. So you do need to think about these things, and staff is an important aspect to that. Very briefly, restrictive covenants in contracts, stopping people from competing against your business. Always hairdressers. Always hairdressers. And it's amazing. This is what usually happens. Sellers excited about selling their hairdressers and moving on. Buyers excited about coming in, so they introduced them to the staff 3 months before the completion date, okay? So all the hairdressers are sat there, of course, they're cutting hair like, you know, going, oh God, I don't like that Jane that's coming in to buy the business. And then it all starts, and it's a hurricane. And before you know it, they get together and they've decided they're going to set up their own salon, but they're going to wait for the buyer to buy. so that on the day of completion they can all walk out in one go. And it happens time and time again. So what do you do? Like, restrictive covenants on the seller are fine, but you need to be careful with these, because actually it has to be reasonable, and it can't be a restraint of trade. Usually what you do is duration, a time limit, and distance. So let's say, for example, you were selling your hairdressers in this example. You couldn't turn around and say, I don't want the seller to be working within 50 miles of this salon and for a period of 10 years. That would just be completely unreasonable. But you know, something like 1 mile and 12 months or 18 months would be considered reasonable. So you have to be fair. I've got a very good briefing note on this, so I can send that to anyone that's interested in this. But restrictive covenants with staff, they are another minefield. But essentially the rule is this: if the person has some managerial or knowledge of the business's internal workings that could affect the business long term if they left, it is probably justified to have a restrictive covenant. If, however, it's, you know, John in a tea room or post room, and you're asking him to not work for another law firm within 12 miles and 18 months, you're not going to get away with that. So it's all about reasonableness, and it's about making sure if you've got a director who leaves, you can rightfully say that they know about our marketing strategy, our business strategy. It's not right for them to be able to work in the same area or for a distance, a time limit. So that's restrictive covenants. So they go in the contract. Tax efficiency, I don't want to play on this a lot, but tax is a really big part of business sales and purchases. I've done this twice, and it's called Seed Enterprise Investment Scheme. The accountants here will know about this. But if you have a client that's buying a business as a going concern, and the business is they're either setting up something new in the place or changing it fundamentally so it can be considered something new, or it's less than 2 years old. If you buy as a limited company, so you don't buy in your personal name, you can use a tax scheme called Seed Enterprise Investment Scheme, potentially, if the business forms part of this. SEIS is really good, because if somebody has less than 30% of the company and puts the money in for the purchase, they get 50% of their investment back against their last 3 years and the current tax year. So let's say someone's a high taxpayer and you're buying a business for £150,000 and you give them 30% of the company, and the company buys the business and it qualifies, and it can, a lot of businesses do, they will get £75,000 back from HMRC against their last 3 years tax or the current tax year. So these are considerations that you really need to have with your client right at the start. If you're a bank manager, Dan, for example, you speaking to someone, or Ian speaking to someone about, you know, I'm buying a business, these are things that you really need to consider. There are other stuff as well. I'm amazed how many times people get accounts for buying a business and they don't go and speak to an accountant about it. We just had one recently, and the client, we were buying the newsagents, I believe, and he was paying quite a pretty penny for it. Got the accounts, he said, what should I do with these? And we said, let's go and see an accountant. You need to see an accountant about that. Does it stack up, the value of the business and the accounts? We can't advise you on that, we're not accountants. Didn't go and see an accountant. Sure enough, purchase completed. We had a warranty in there that the accounts were true, accurate. Seller then immediately went to move to Spain. So we've got the warranty, we can sue the seller, but go and find him in sunny Spain. And that's the reality, is that obviously you need good accountants advice as well. There are other stuff like VAT that we'll go on to. So that's essentially what I do on the business side of things. Moving on now, it's going to be my sidekick Hamish is going to talk about the property aspects, which is a completely separate aspect to business sales and purchases. Hamish?